This meeting is available with video recording, and all meetings are televised and available on demand by Chelmsford Telemedia. The public input shall be limited to statements from the public relating to any issues within the jurisdiction of the Chelmsford Zoning Board of Appeals that are not currently the subject of a pending public hearing before the Zoning Board of Appeals. Public comment may be on any pending public hearing, shall only be heard during such public hearings, and shall be limited to 3 minutes in time. Does anyone like to have public input at this point? Seeing none. We have no administrative reviews. We have a new public hearing, 2 Indian Drive. David Capragino requesting a modification to a previously approved variance and/or new variance under zoning bylaw section 195-8, nonconformity for construction of a new enclosed porch along the back of the house, which will be keeping with the previously approved variance, allowing an 18-foot side setback and any other relief deemed necessary. This property is located in the residential RB district. Someone here on behalf of 2 Indian Drive? You want to go to the podium? Give us your name and address, please.
My name's David Caprino. I live in 2 Indian Drive, and as was stated, we're looking to have a variance modification so we can put an enclosed porch off the back of the house. We have presented building plans, which I told I wasn't need, but not in that necessity of grandeur, but you guys should have a copy of those. I dropped those off as far as what we want to do on the property. And if not, I have a copy, if anybody wants to look at them.
I think we're going to get them
I'm
up on
gonna
the
pull
screen.
them up on
Okay.
the screen. Yes, let me grab that for you. Party application. Oh, where'd it go? Oh, okay. Hold on just a moment. I just realized I downloaded twice the architectural plans and not the actual plot plan. Hold on.
Okay.
I have a copy of the plot plans if you need them, or
I'd like to get on the screen. We could look at that if you have it, though. That'd be fun. Let Becky get sorted out.
Sorry about that. I can get that in screen. Just give me a minute. So this is the Zoom. This is the actual as-built from the
Okay.
previous variance, and then this is the zoomed in, the proposed in red. And let me just grab that on here.
So the corner of the new would be 18 feet as well as the existing,
correct.
I guess in line. Let's take a look at that. The red is the proposed. Oh, here we go.
Should come up in a second. Oh, I apologize. Hold on, let me see if I can get this going. That's not gonna work.
No, I don't think any of
It's not on
This is HDMI 4. That helps. Hand that around, Stephen.
Oh, is this a,
Yeah.
Peek.
we'll hand that around. Yeah, those-
oh, thanks.
Right there, the red is the
Sorry about that.
That's
anticipated.
okay. Will it help if I try emailing it to you now, or?
No, actually, my laptop isn't,
Yeah, it's on your laptop.
it's not
They won't buy the house.
going on there.
Yeah. So they're
This
actually
works
just,
too, I don't know why it's not working today.
oh, so this corner,
Yep.
right there. That's the,
Yeah, yeah, you have it.
Thank you.
So Brian, from a procedural point of view, does this count as it says modification and/or new? What does this come under, a modification or a new?
Checked with Paul, and he said either was acceptable.
Okay.
I thought the modification was more practical. One or the other, I mean, it just, it's not increasing the nonconformity at all.
Yeah, this red.
It's what we granted.
I deliberately kept it in that because I thought it would make it easier. Because if we could have made it bigger, it would have been ideal, but we tried to stay within that 18-foot variance that we had to
You'd
begin
have to ask
with.
for an additional
Yeah.
relief.
I thought the modification was more appropriate, but I advertised as both, just in case, since it is the same relief that was given before.
It's funny, it's almost the same thing I
That is
asked
a
for.
theoretical continual
It
line.
is, yeah. I just wanna make sure they all get a chance to see it. Sorry, it's not coming up on the screen. I'm gonna go back to the other computer and get the other forms on. Hopefully that one comes on now.
Does anyone have any questions of the applicant at this time?
pretty straightforward, so.
Oh, you already have.
Have it.
Okay, do we have letters?
Yes. That's a duplicate.
From Sheila Joyce, project engineer. Dear members, this office has reviewed the project application, plans, and documents submitted to the DPW on May 9th, 2024 for the following public hearing. 2 Indian Drive is requesting a modification of previously approved variance and/or a new variance under the zoning bylaw, section 195.8, nonconformity for construction of a new and enclosed porch along the back of the house. As a result of the review, the following comments. The proposed addition will be over the existing sewer service. Care should be taken when excavating the foundation. Should the sewer need to be moved, it must be done by a licensed contractor, and both sewer and trench permits are required through the BPW. Erosion control devices must retain the sediment on site. They must be installed prior to any work, demolition, or earth disturbance. Consideration should be made to install roof drain dry wells on the new two-season porch as the property is located well within the Zone 2 wellhead aquifer protection area. If you have any questions, please call Sheila Joyce. I have no concerns from the Board of Health. I have no concerns from Fire Prevention. I have no concerns from the Chelmsford Water District.
No concerns.
The assessor has no comments or concerns. That's a new one for us. And that's just a letter from the attorney. So those are the extent of my letters.
David, I printed out a copy of the DPW letter.
Okay. And it was that Susan Joyce, is that what that?
Sheila Joyce?
Sheila Joyce, thank you. She's saying that there is a septic tank underneath there?
No, she's saying your existing sewer line.
It's well south of it.
I'm just
Yeah, okay.
reading the letter.
All right,
I
yeah.
don't know, but care should be taken.
Yep, definitely.
I'm going to open this up to public comment. If anyone has, like to speak in favor or in opposition to this, now is the time. Seeing none, can I get a motion
I'll
to,
make a motion to close the public hearing.
For 2 Indian Drive.
Second.
Second by Peter. Motion by Charlie. All in favor?
Aye.
Opposed?
Closing the public hearing?
You have more
This was-
questions?
That was to close the hearing, so,
Close the public.
yeah, but you're asking if we're opposed to closing the, I never thought you asked that before.
Becky
Okay.
sent me a
Size is
form
the
on how to
porch.
do it correctly.
Okay.
So was I doing that right? Maybe not.
Threw me off, okay.
Before we vote, I just had one little question for the applicant. It says 2-season porch. You mean 3-season?
No, we're not gonna insulate it or finish it, it's just existing where the garage was when we went to the variance, there was an enclosed porch that was there. And it's seen its days, but we preferred the garage, but now we missed the enclosed porch, because we want to be able to go out there and sit out there on rainy days, bug nights or whatever. So it's basically just an enclosed porch.
All right. Good.
What's-
I'm good.
Just what's the size of the porch? What's the size of the porch? 16 is one way, I think.
12 by 16.
I had a
12 by
little trouble
16?
finding the footprint.
12 feet coming off the house, and then 16 feet wide. And it will start 16 feet off the corner of the garage. So it puts us within that.
So he runs parallel to the property line at 18 feet, which is what we allowed with our original variance.
Right, and the property is on an angle, so it's not a square back property. So the corner catches the 18.
What was the,
That's
Now, I just want to mention that with the garage and with the porch, it's a total of 836 square feet. Just want to mention that, that's all. The addition of the garage, which was previously approved, and the porch, the total is 836 square feet, 644 and 192, I believe.
That sounds pretty right to me.
Just wanted to note that.
Okay. Noted.
so based on the list here, I wasn't at this original, when it went through the first time, what was the hardships for? Does
I can
anyone?
pull that out for you.
I would imagine it was lot shape, but I don't.
Shape, I believe.
Yeah, it was lot shape.
It was lot shape, and everybody said, why didn't I put it down the other end of the house? And the cost was gonna double just to get the garage down that end of the house. And we're trying to create a single-floor living for the future, basically. Couple steps up and we're in the living area.
Do you want to look it up? I mean, lot shape is definitely a good argument.
Lot shape, topography, and sewer location.
Thank you.
Existing basement stairs do not allow for smaller garage dimensions. That was in note 2.
Okay, thank you.
Did you finish the garage
The
already?
garage is finished, yeah. The house is all complete with the exception of some finished painting.
Any further questions? Yes, sir.
Just one question. So what's the hardship for this one? Because the first one, the first prong is the shape factor, the second is the hardship, so what's the hardship for this?
So they're coming back to request a modification to the previously approved, in that they're proposing to put the addition of the porch at the same,
When we
setback
grant a
that was
variance,
approved.
it's, like I say, perpetual. It continues the whole length. So they're not increasing the nonconformity at all.
Yeah, I just wasn't sure, because it said new or modification, so I wasn't sure if it's a new one.
I worded it that
then-
way at the time, just to make sure that the legal notice covered both bases before
Okay.
asking town council
Okay.
if it should be one versus the other.
So it is the modification? Okay.
Yeah, neither, and the modification seems an easier route. Um, I don't know if we need a second hardship.
Well,
It
if it
doesn't
was.
change. The
if it was
hardship
a-
doesn't change.
Yeah, I meant like in the sense, I thought it was a new one. That's why
Right,
then it
right.
would have
So
been,
as a
that's why I was
modification, I
asking.
think, I'm comfortable with
Yeah, no, I agree.
not requiring a specific new hardship,
Correct. Yep.
I would think. Any further questions?
It was lot shape, topography, and location of,
Sewer location, existing basement stairs to not allow for smaller garage dimensions in an existing lower level garage on the opposite side of the house. So basically the hardship, what he was talking about on the other side of the house, so that's how we worded it there.
Does that apply for not a garage? Because we're not doing the sewer, like, where the sewer line was going, stopping the garage from going on the other side of the house, this isn't going on that side of the house. So,
That's my question.
yeah. And
But do we have a concern where we've agreed that this 18.2, or 18 actually is acceptable? That continues, that doesn't, you've granted that.
yeah, I'm just,
This line now, we've granted. We didn't grant it here, we granted it here.
okay, so,
There's no more nonconformity shown with the second addition. I don't know, new to me, but
I mean, I guess I want to make sure that the expectation is that if he was gonna put a pool in the backyard and it was gonna be 18 feet away from the lot line, and the pool was on the opposite side from wherever if he had like topography issues on the right, and he's now putting the pool on the left, and we're saying, well, it was topography before, but we're not on that side of the property anymore, it's just, we had a variance with topography, so topography is his hardship. Even though it doesn't affect the new thing going in, it affected the original. You understand?
I do know, I know what you're saying.
Okay. So it's just the hardship attached to this, and it's just good, moving forward, because we have a variance, it's got some hardships attached, and they are perpetually attached to this variance, is that?
Right.
The idea is that he's not going any further, though, right?
Yeah.
What we've granted is that 18-foot line, right, essentially.
Along the
So,
entire
and that is
property
just
line.
continuing on.
We're not creating a new
Anything, you're not
nonconformity,
creating a
would be
larger,
cause for a new variance. We're modifying the existing variance.
Right.
I think it would be acceptable. I don't, I wish Paul was here to clarify. Jose, you wrote the denial letter. Is it right to think that we are okay without a hardship for this?
Yeah, because you already granted the variance, so.
And that's the entire
Right,
property
yeah, Yeah,
line.
just to modify that variance without encroaching into setbacks or.
Right. That's what I see being acceptable, so.
How close is this to the property line?
It would be 18 feet.
That's what I'm looking for.
It's not on
feet.
this
Scroll
plan.
down.
That's the one you passed around. No, I don't have to see it, I just need a number. I'm good.
18 feet.
18 feet.
All right,
Sorry about that.
See, the original is
I'm-
18 feet,
that's what I was looking for.
and here's 18 feet again.
It's supposed to be, is this 25 or standard?
I think that would be the side setback, and it would be 25.
It was 21 and a half with our old porch, and then when we got the garage variance, we
Yep.
got the 18 variance.
Are there any further questions?
not for me.
I guess we'll put it to a vote and see what
So we had
everyone's
a motion
thinking.
on table just to close the public hearing,
Correct.
and it was seconded. I don't believe we voted on that.
Right,
Because
Yes, we
then
did.
We paused, we did,
We did.
because then
We
we were asking
closed it.
questions. Okay.
I think we also, everyone voted in favor, and then when he asked about opposed, that's when I,
Becky
Threw
sent me
things
a
off.
little note to correct the things.
No,
that
just to
were
mention
recommended.
it's to mention the motion in the second. I just want to make sure that once we
Okay.
close the public hearing, we can't be asking more questions, so do that right before the vote. Do you know what I mean?
Right.
Yeah.
So we have a closed,
And Glenn is voting on
Public
this one
hearing.
because Jamie's not here.
okay. Would someone like to make a motion in the affirmative?
I'd like to make a motion in the affirmative, make a motion to approve the modification to a previously approved variance for the construction of a new enclosed porch at 2 Indian Drive.
By Charlie, do I have a second? By Steve? All in favor?
Aye.
4, opposed?
Or one?
1. Motion passes. I guess you can't say it. Good luck with it.
Thank you.
Okay.
Do I see terminate?
I will be emailing you when the decision document is ready, and then I'll give you instructions as to how to follow that.
Excellent, thank you.
You're
Have a
welcome.
good evening,
Have
everybody.
a good evening. Do you mind just putting a pause, and I'm going to ask for technical help to get the screens back up and running?
Yes.
Because now the main
We're
computer's
going to take a
not.
5-minute break
not
for
running.
technology's sake.
Thank you.
For the continued operation of an electric substation and the construction of a new control house and variance per section 195-102B2 for inadequate front yard setback of 40 feet for the new control house. Any other relief deemed necessary. This property is located in the residential RB district. And this is not National Grid, but Mass Electric.
National Grid is sort of the doing business as.
Okay, okay.
We all set, Mr. Chair?
I believe so. If I could get your name and
Sure.
address for the record.
Absolutely. So for the record, my name is Joshua Lee Smith. I'm an attorney with the law firm of Bowditch and Dewey, here today representing Massachusetts Electric Company, which does business as National Grid. We've got a brief slide deck that we'd like to run through just so we can show you with some photographs and plans what the company is proposing to do. I see the slide deck. So Becky, if you could advance
Yep.
a couple of slides. Great. So the next three slides here are just photographs of the existing site. I'm sure the members are familiar with this site. This substation has been in operation for decades. It's about 65 years that this substation has been in operation. Again, it's right off of Concord Road, 15 Concord Road. Becky, if you could advance to the next slide, please. And this is the street view from Concord Road, looking from towards the substation on the northerly and southerly side. The substation itself contains pretty typical substation-related equipment, transformers, circuit breakers, switches, all secured, and Becky, if you could advance to the next one, all secured by a security fence, which is currently today, it's 7 feet plus 1 foot of barbed wire. This is a front-facing view, and as you can see here, in this particular photo, you can see that truck there. This is an unmanned substation, which means that usually there are not personnel that come to the site, but from time to time, personnel does come for testing, inspections, maintenance, repair, etc. Next slide, please. So this is an aerial depiction, environmental resources map that shows another view of the site. And on the right there, just to get your bearings, is Concord Road. And then on the left, in the sort of square-shaped area, is the substation itself. It may be a little bit difficult to see, but the substation, as I said, it's enclosed with security fencing today. The red rectangle on the lower portion of the area, that's it, right there. That depicts where this new control enclosure equipment building is going to be located. This is essentially, you could think of it as a glorified equipment shed. This will enclose various control equipment that's necessary for the operation of the substation. The expansion area, which is the primary part of this project, is, again, right in that area where the red rectangle is. The expansion is of the existing fence line. So it's in the southerly portion, running flush the same distance along the front along Concord Road, consistent with the existing fence line that exists today along Concord Road. And that expansion area is going to be about 624 square feet in size. Going back to that enclosure, the equipment enclosure, that building is going to be approximately 336 square feet in size. And as part of this expansion, this modest expansion, there will be crushed stone that will be added in order to expand the yard. The security fencing will be improved up to National Grid's current safety standards and security standards, which is 8 feet plus 1 foot of barbed wire, and will have tightly woven mesh for security reasons. Can you advance to the next slide, please?
Mm-hmm.
So this is a depiction of existing conditions of the site. As you can see, there are a couple of access points in order to get into the substation yard itself. The existing equipment here you could see running along from front to back. And again, where the expansion area is going to be located is in the southerly or in the bottom portion of this drawing here. Next slide, please. And this is the site layout, the engineered drawing that we submitted. And again, the expansion area is on that lower portion of that drawing. Next slide, please. Here you can see we've provided a couple sample photos of what a typical enclosure, equipment enclosure, how another ones at other sites, how these generally appear. And again, circled there in red is the general area where this equipment enclosure is proposed to be located. So a couple of views of a typical enclosure on this screen. Next slide, please. I'm sorry. Why don't we land back on that photo? We could stay right there just for the time being. So again, a lot of the equipment here, as I mentioned in the beginning, the substation itself has been here for decades. Over time, there have been some replacements of equipment, but at this point, National Grid did an assessment, and they determined that a lot of the equipment here does need to be replaced. A lot of it's aging, and this improvement will obviously provide overall improvement to the reliability for electric service for the town. Mr. Chair, you had mentioned at the outset that this property itself, from a zoning perspective, is located within the single residence RB zone. And the relief that we're seeking tonight are in two forms. One is with respect to a variance. The minimum front yard setback requirement for this particular district is 40 feet. The equipment control structure that we're proposing will be 22 feet 5 inches from the property line. The reason for that really pertains to the The substation yard itself, although there's a proposed expansion, it is relatively small. There's not much room in order to provide additional equipment. There are clearance requirements with respect to the equipment. And as was depicted on that environmental resources map, there are constraints with respect to soil conditions and topography. So surrounding the site, much of this property, again, which is about 2 acres in size, does consist of jurisdictional wetlands. And so this project also is before your Concom right now as well. So they're reviewing that in terms of the wetland jurisdiction and order of conditions. So the site is constrained, relatively small, and does have challenges with respect to the soil types surrounding. So there's really limited areas in which where this control building can be located. The other form of relief is in the nature of a special permit. Essential services use is permitted by grant of a special permit in this particular zoning district, so we are seeking that as well tonight. I'm sorry, I should have announced this in the beginning. They're representatives. The folks sitting here in the front are representatives of the company. They're here to answer any questions that the board or the public may have. The last thing I do want to say is that this project is somewhat time sensitive. We have met with Jose as well as Evan Belansky and other town officials over the years. This project was at one point slated to commence a few years back, but then COVID happened. There was a delay, and then there was actually another delay. So it's sort of began and then put on hold at various points. But at this point, the company is ready to go. They are looking to commence work in August of 2024, and the total duration time, approximate time for construction and energization of the improvements is about a year. So we'll start in August in terms of commencing work, and then hopefully get this energized, up and running in about August of 2025. So with that, we're happy to answer any questions that the board or public may have. Thank you.
Glenn?
Did you say that the fence is going to stay where it is in front of it?
The location of the fence in relation to the front lot line, which is basically the street,
Right.
will remain along that same plane. So
Be closer to the street?
it will not be closer to the street. It will be, so the fence that exists today that runs parallel to the street, the expansion portion of the fence will be that same distance to the street.
Will this bring more power to the area? Available power?
I want to yeah, come on.
Curtis Richards, 905 Main Street, Dunstable, Massachusetts. The answer to that is it's more power is a tough term, but more reliable power, I think, is what we're going for in this project. Again, Josh had mentioned that the substation itself is a few decades old. As things age, they need repair, replacement. It was on one of the earlier slide decks, but there is a shed labeled. That is what is the existing control house. So with a larger space, we can add more protection schemes, more fail-safes for the substation to provide more reliable.
One of the reasons I bring that up is more people are using home
Yep.
electric charges for their vehicles, and so need power. Also, I used to live very close to that. On the back of my side of my property was on the power lines. I was very close to that, and if any place in Chelmsford's going to lose power in a storm, it was that section of town. But I think it had more to do with all the trees running through all the power lines down there. So, thank you.
You're welcome.
You said you're gonna heighten the fence, though. I mean, area-wise, it stays pretty much where it is, but you're gonna add a foot, you're gonna put up a new fence that's more effective.
About 280 linear feet of new fencing. The height, you're correct. So the existing fence height is 7 feet plus 1 foot of barbed wire. So a total of 8 feet in height. National Grid standard, as well as Eversource and a lot of other public utility standards with respect to security, fencing height is 8 feet plus 1 foot of barbed wire. So a total of 9 feet.
Okay. Thank you.
Is there any choice as to the color of the building? You showed two examples of how buildings. One I think was more white, one was gray. Is
Do
there?
we know?
Any reason you choose one or the other?
The specified color, I believe, is coined ash gray is the color. So I think it is on the lighter side of gray is what we've spec'd for the control house through our vendor.
I want rustic red.
We have the PM here. She can.
Chelmsford maroon would be okay too?
Any further questions at this time? I think none of us are really up to speed on what's required. We're going to have to take you at your word that this is the ideal place for it on the site. I can see the restraints that you have. It looks like you're minimally expanding the fence area to accommodate it. Obviously, power is public safety. As far as the variance goes, maybe Jose can look and see. As far as the 3 tenants go, we can also approve a variance for safety. Is that correct?
In regards to the fence?
In regards to the project, but if, we want to have topography, soil conditions, lot shape, but we can also approve it for safety. Would this fall under that category as public
The category
good,
as well,
or,
yeah.
I mean, you really can't not have electricity, and you certainly want it as reliable as possible, so I'm just looking for a reason to approve it other than,
So the entire fence too is being replaced? Yeah,
Correct.
okay.
I'm just curious, and I don't think this would affect how I would decide something like this, but you'd said this is primarily, to replace aging equipment, and it's gonna be more reliable power. Is it built in so that if and when the time comes, more power can, could more equipment create more power, then you don't have to replace this again? Is it, I guess, designed for expansion, is what I'm asking.
Exactly. Yeah, absolutely. Most of the equipment that we're ordering these days is at a higher amperage rating, just to handle that increased load down the future. It's hard to say. I'm sure there are others at National Grid looking into this, but that's the idea. You mentioned earlier electric vehicles. We're trying to get to that place as a company that we can provide enough demand or enough supply to keep up with the demand that we're seeing. So,
'Cause I can imagine, if things weren't quite like that, 3 years from now, you come back and say, we need a bigger place because we didn't expect everybody was gonna buy an electric car, this kind of thing.
yeah. So in
I would
addition,
imagine you guys have looked at, the projections.
I think,
Are comfortable with it.
I think the
yeah.
chairman's right. We have to trust to your expertise on most of this.
if you're familiar with Chelmsford 9, I don't know the exact address, but it's across from the 110 Grill. We just
Yeah.
removed that because of some reliability issues, and then it did a distribution conversion just to get that
Just
that
removed
site.
it
Yeah.
altogether. Yeah, I did see that going on.
Will the heavy-duty part of the installation impinge traffic on Concord Road at all?
No, we'll have plans in place. This is slated for in-house construction. They'll put together health and safety traffic plans. They'll work with local PD as needed just to make sure that we're not impeding that. There will be a crane that has to take to, the control house is a prefab building, gets shipped in on a truck, and they just pick it and set it on the foundation. So I imagine during that activity, we may have to take up at least one lane, but we'll have local PD giving us a hand with traffic control at that time.
And the area is such that a reroute would not be, for a day, if that was the case, or two, would not be, too much of a problem. They go Harvey Road or just around it altogether quite easily, I would think. Any further questions from the board at this time?
You mentioned safety. What is that in the?
Yeah, it is. I don't have it. Are you familiar with the safety aspect of the variance?
I don't recall at this moment, but we can look into it.
We used it before, and it made sense.
We can also take into account the wetlands being a constraint on the property.
I guess
Mr.
lot
Chair.
Size.
The lot size isn't gonna change, the wetlands aren't gonna move.
The lot size is what it is, and they have to fit as much equipment in there as possible, so.
Exactly.
Yeah.
Yeah, if I may, Mr. Chair, as was discussed, the significant constraint pertains to the sensitive environmental soils conditions that surround the property. With respect to safety, we did include footnote to a case that raises safety in connection with the grant of a variance, and we indicated that where a variance diminishes risk of existing harm or prevents greater risk of harm that would result from compliance with the zoning ordinance, such hardship may merit a variance. So,
That is what I think I was referring to. I'm trying to
Right.
find it, but I'm not having any luck.
the 2016 case.
Thank you.
So you're correct, Mr. Chair.
Hang ahead on. We have some letters. It's from the Chelmsford Fire Department. Dear members of the board, in regard to the proposed renovation of the electrical substation at 15 Concord Road, the Fire Prevention Office provides the following comments. This office has no objection to this project. The Mass Electric Company and the National Grid US have been valued partners in the Chelmsford Fire Department. Chelmsford Fire Department has found their employees to be competent throughout the many and regular interactions with members of the National Grid staff. Fire Prevention Office requests the applicant provide a NFPA 241 construction site safety plan as part of the building permit process. We also request a pre-project safety meeting to be held on site so that the fire prevention personnel can familiarize themselves with the project. The applicant can reach out directly to the Fire Prevention Office to schedule this meeting. The Fire Prevention Office would recommend approval of this proposal with these conditions and would respectfully request that this letter be made part of the permitting and approval process. Respectfully, Danielle Kostafis, Captain, Chelmsford Fire Department. I have a letter from Sheila Joyce, project engineer. This office has reviewed the project application as plans and documents submitted to the DPW on May 9th, 2024 for the following public hearing on May 16th, 2024. 15 Concord Road, Massachusetts Electric Company, requesting a special permit under the zoning bylaw, section 195.5, use regulations for essential services, the continued operation of electric substation and the construction of a new control house, and variance per section 195-102B2 for inadequate front yard setback of 40 feet for the new control house and any other relief deemed necessary. This property is located in the RB district. After review, this house has the following comments. The DPW has no comments regarding the ZBA filing. A lot of letter for a little gain. This is from Jose Negron. He's already been denied, so we know that. Town engineer has no concerns. The police department have no concerns. The water district has no concerns. And that's just a cover letter. Those are the extent of the letters I have tonight. I'm going to open it up to public comment. If someone would like to speak in favor or opposition to this application, now is the time. Seeing none, are we ready to close the public hearing?
I'll make a motion to close the public hearing.
Peter made a motion, second?
Second.
By Glenn. All in favor? Opposed? None. I guess my opinion is it's probably something we need. I know we don't have the technical support to make an independent decision, but I want to turn my lights on, so.
Great.
I just, I can understand that you guys have put a good amount of work and time into seeing that it goes in the best place practical. The fence itself is not going to change. That's really been the demarcation of the property for 65 years, apparently, so you have my support. Anyone care to make a motion in the affirmative?
Just questions from anybody?
Or if there are more questions, feel free.
There's a question.
Yeah.
So we have to make two separate motions, one for the variance and one for the special permit?
That is correct.
And the hardship is lot size.
Soils
I think it would
topography.
be safety.
Safety, soils, and topography, or
What-
soils, because
what
the
are the-
wetlands.
Oh, okay.
It is wetlands, too, as well, yeah.
It's the wetlands, so you have soils on there as a major factor of limitation. They're within riverfront zone.
You only need one, right?
Yeah, you
You
don't
only
need the
need
three,
one.
you need the one.
It's an essential service and safety.
Okay, I'll make a motion to approve the special permit under zoning bylaw, section 195-5, for the 15 Concord Road,
Electric substation.
construction of a new control house at the electric substation.
Second.
Second by Charlie. All in favor?
Aye.
The special permit passes.
Okay.
Now we look for a motion for the variance.
You're so good at it, Steve.
I'd like to make a motion to approve the variance per section 195-102 B2 for an adequate front yard setback of,
Actually, it's the other way. No, I'm sorry, yes, variance, sorry, I had it
He's
backwards.
right.
an adequate front yard setback of 40 feet for the new control house, with any other relief deemed necessary with respect to the letters read into the record, which I neglected on the first one, for 15 Concord Road for the new control house at the power substation.
Second that.
Second by Charlie. All in favor?
Aye.
Unanimous.
Thank you very much.
Bring on the power.
I'll follow up with an email once the decision's filed with the town clerk.
Excellent.
And that is-
Thank you, Becky.
You're welcome.
Thank you, members.
Thank you.
Yeah, you gotta go on faith at that point, but they're doing their best.
So just as a reminder, this is continued, we opened and continued with no discussion last month.
So it is continued.
Right, it was open because it was posted for last month.
Right, we opened it without,
Discussion without.
or,
discussion, so it's the
testimony.
first day of testimony.
So we have a continued public hearing, 43 Bartlett Street, Elizabeth Gravel, trustee, requesting a variance on the zoning bylaw, section 195-61, to allow the continuation of a pre-existing detached limited accessory apartment. I'm just rereading this because we opened it last month but took no testimony. The detached main dwelling and any other relief deemed necessary. This property is located in the residential RB district. Good evening.
Good evening. For your record, Douglas Hausler of Lampert, Hausler and Rodman with offices at 10 North Road in Chelmsford. We have just sent, because there was some confusion between the applicant and myself about getting some information over to Becky, there was a certified plot plan that we just sent over by email to Becky, and I don't know if she can bring that up
I'll just
or
need a
not.
couple minutes. It should
I
work
do
this
have what we consider a hard copy of what that is. And I'll see if she can bring that up, but I'll describe it in the interim. You asked for some type of a certification about the dimensions of the property, and there was a concern about the garage being an encroachment onto the private road, King Road, or King Street, excuse me, it's a paper street. So this is, what you'll see up on the screen, hopefully, is a 1991 plot plan for this property that was certified by a registered land surveyor, and it lists all of the dimensions of the property, which is what your requirements are. That's not the one we sent over.
I just have the locus up.
Oh, I'm sorry, Becky.
That's okay. I just need another minute.
Yeah, no, that's fine. And then, as that's going on, I just wanted to remind you, so that, your issues were, you needed something to be as a survey, so we've now provided that. I'll note that the survey itself specifically identifies that the garage was an encroachment onto the paper street. So it's no secret to anyone, including anybody who would have a right to claim a right title or interest in the paper street. My client has used this property exclusively and is a hostile, meaning to itself. No other person's challenged it. It's clearly out there, it's notorious. It's been open and it's been continuous for more than now 33 years. I think it goes even beyond that, but we hit adverse possession and then some. So I don't think we have an issue with respect to the fact that the garage is there. I will also note that when the sewer lines were being put in, and the town has been aware of all of this all along, but one of the pieces of documents that we found in the town records was an as-built drawing by the DPW Sewer Division in May 18th of '09, so 15 years ago almost to the day, that was built and accepted by the DPW Sewer Division. And it specifically identifies the garage as an in-law apartment. So the town has been aware of the use of this property. The latest is '09, and there were things even earlier than that, I think, with the sewer department when they were putting in the main line along that road. And there were other documents from other departments that were clearly aware of the fact that this garage, this exact location, this exact structure was being used as an in-law apartment. So I respectfully suggest that while the building inspector said there was no permit ever taken out, that is true for the use of the building. But the fact is the town has known about it for at least 15 years and more. And I think it would qualify status for grandfathering under that, because we would be able to show that, in fact, the town was clearly aware of it. Most importantly, I know that all of the town was aware of it because it was assessed separately as an in-law apartment. And the town's been collecting taxes on that property for 30-plus years as a separate property almost. So there's no argument the town knew what the use was. There's no argument about where it was located. There's no question about the encroachment issue, because it's going to be adverse possession to the extent anybody wants to challenge. And I might add, now we've been before your board on this hearing several times, and there hasn't been, to my knowledge, other than one person, a single abutter complaining about any of this, much less the structure. So they certainly were given certified mail notices. So if someone felt that this was their property and that we were encroaching, they would come in. They'd oppose it. There is not going to be that. We've talked to the neighbors. With the exception of one neighbor that we are aware of who's appeared before you before, we are otherwise, everybody's satisfied. In the prior hearings, I described why this does not affect anybody's property in that I'll call it district or that portion of the town, is because it's so well hidden. The landscaping is there. It was completely mature and surrounding it. We've also provided you with the soil testing that was done and witnessed by a professional engineer, Katie Enright, and she identified the fact that they hit ledge very early on and that there was no other likely place to construct some new structure to serve as an in-law apartment. So they took advantage of the extra-sized garage and converted that. So for all those reasons, I think you can grant the variance. We've identified the hardships. You had one concern, and I understand it very clearly, is it's not attached. That's true. No arguments. Somebody raised the question about, well, this could become a precedent-setting thing. That's not true. There is no basis for this to be applied as a precedent to any other application that comes before you. This was, because first of all, the facts would be completely different. We have 30-plus years of the town now taxing it as a separate in-law apartment. I don't think you're going to find that. This was an as-built apartment for 30 years. So we're coming in under a variance standard on a bylaw that, in effect, doesn't really apply to this situation, because the bylaw implies a new structure.
So I understand your criteria, but they're just not applicable. And I think you have the right, we've met all the other criteria, to make a decision that this allows the board to vote in the use and allow them to continue using this as an in-law apartment. And I think I'm going to quote the chairman loosely, because he just said, with, Mass Electric, you got to kind of be practical about this. That's exactly what this is. It's a practicality. We're not looking for anything. We're not sneaking around doing something improper. It's 30 years of well-known use. So I ask you to use your discretion and I'll grant the variance. I'm happy to answer any questions that you may have.
There was discussion at one time about putting a covered walkway. That's gone?
That's gone. It doesn't make sense. It would be a 40-plus foot long walkway.
Right, that's not gonna
That would
happen.
look like, to be honest with you, like the area going from the White House to the West Wing. Doesn't make sense. No one's going to see it. It's so hidden. It's so far back.
No, I was just, I
Oh,
thought,
was
I thought you were going forward with that, and I didn't see it
Now,
anywhere
we looked
here.
at it, we said it's just the distance. It has no practical effect other than compliance with the strict language of the bylaw, which in this case really doesn't apply.
Gotcha.
But otherwise, I would say if it was a new structure, I would agree with you.
Jose, do you feel that there's some merit to the grandfathering of a 30-year-old in-law?
Well, I have no power enforcement power for any structure that is 10 years and without building permit, and no zoning enforcement power after 6 years. So the question here is really the use, not the structure itself.
But with respect, may I follow up with that,
That's okay.
Mr. Chairman?
Certainly.
I think Jose is correct about another thing implied there. What we've been talking about is the structure. That's been the big hangup for most of the people, is it's not physically connected. That's a structural issue, it's not a use issue. And as he's saying, structure isn't what's before you, it's use only. Makes it a little easier for you to grant the variance.
Glenn?
I want to congratulate Attorney Hauser. He seems to have taken a lot of the issues off the table and presented logical agreements for it. But the one that still remains is that it's not attached. And the town bylaws clearly state that ADUs must be attached. I was at a town meeting recently, and I was talking to someone who was there, who's moving out of town because they would stay in town if they could build an ADU that was detached, and they're moving out because of that reason, because it has to be attached, and they needed it detached for whatever reason. So that's really the crux of the problem. Do I agree that for all practical purposes and being a reasonable person, that it seems to be warranted, to be acceptable? The rules are the rules, period. Someone can make an argument against why we should ignore the rule.
I can. I think I did. With respect, the other person, whoever you spoke with at town meeting, this board can consider a variance if they were warranted. So I don't know if they've ever investigated it, but that's up to that person. My client has asked for the variance. My client, as confirmed by the building inspector, the structure, which is what is being talked about here, the structure of the rule, isn't what's at issue here. The structure is grandfathered. Jose has said that time and time again. He's put it in writing. So I understand your concern, Glenn, but I'm just saying that isn't the issue before you. It's now the use, and only the use, not the structure.
Seems to me the whole purpose of this board is to look at things like this that may not be copacetic with the bylaws.
That's what a variance is.
That's the whole point. That's why we're here. I mean, like you said, the structure's,
He answered it.
it has been there.
Unless you have any other questions, I'll sit down.
I think we're good for the moment.
And you can see that, I know this is cut off, but if you, oh, you can see it over here. It's been cut off, but that is registered land surveyor stamp. And it clearly shows all the dimensions, including the fact that the garage is wood and it's in the street, and it even says that. So knowledge about this is as well-known as where the town common is. There's no secrets.
Who had access to that road, do you know? Does anyone know what that road is or what it was?
It's a paper street.
A paper street,
That's all it is.
so nobody owns it, nobody has any,
I'm sure somebody owns it,
okay.
but it's never been used, at least, especially in that area. I believe that a portion of it was used towards, what's the main drag? Not High Street. Maybe High Street. That curls
So
out.
King Street actually exists on.
Yes, there are
Of
two
High
houses that are like almost on the frontage of High Street that use that portion of King Street.
I'd have to imagine
I
this
can pull that
loops
up.
around.
It loops around, yeah.
I just need to swap computers again. I can pull the
Well, you have
locus
it on
map
your,
up for you.
in your drawing
I'm
here,
on
I
the
think.
Okay, thank you.
Yeah.
Yeah.
Let's go back to the
Oh,
agenda.
no, it's just Bartlett.
Should put it-
All right. Thank you.
You get it there.
And one of the questions that came up last time too is, the fact that it encroaches does not have any, that's not within the jurisdiction of the board. That would be a legal argument by the other landowner who would have a right to appeal it, who was aware of this because we gave notice to everybody. Thank you very much, though. I appreciate it. Unless there are questions.
No further questions at this time? Guess we'll open this up to
we have
anyone who'd like to
letters?
speak in favor or opposition to this application. Oh, the letters we have. Hold on, this-
Brian?
Hold on just a moment. I
They,
just need to flip.
they might say something.
Oh, feel free.
No, it's, the letters might say something,
Yeah, yeah,
not me.
never know.
Sorry.
You always have a lot of wisdom though.
With regard to 43 Bartlett Street, the Fire Prevention Office finds the following. Requests for house numbers must be submitted to the E911 Committee through the Town Clerk's Office in order to distinguish the two dwelling units for emergency responders. The applicant must install additional mailbox or house numbers identifying the two separate residences. The LLA must meet code requirements for smoke, carbon monoxide alarm, placement based on the year of initial construction or significant alterations. This office would approve of this plan with these conditions, and I ask the board to make this letter part of their approval process. Sincerely, Ryan Hool, Captain, Fire Prevention Office. We have a letter from the town engineer citing no concerns. We have a cover letter. We have a letter from the Water District. Chelmsford Center Water District has no concerns with the proposed limited accessory apartment. However, if there's a change of use, the property will be subject to initial bond debt fee and infrastructure fee typically associated with two-family dwellings. Jose's denial letter, which we have, and the police have no concerns. And that is the extent of the letters. Now I'll open it up to comment in favor or against. Seeing none, could I get a motion to close the public hearing if there are no more questions of the applicant?
You think we've asked enough questions so we can close it, Brian?
I don't have questions. Charlie, do you have some questions?
Yeah, wait, I have one question for Jose. Jose, like, if we put a 40-foot walkway between the two buildings, that really has nothing to do with the ledge, does it?
Say that again?
The ledge that
The
was
ledge,
found.
yeah.
That has nothing to do with a 40-foot walkway, correct?
Well, if it's not feasible, I mean, how is that gonna be accomplished? If the structure can't, I mean, their claim is that it's not feasible to do the walkway, the corridor, to connect the two
Right.
structures. So,
But can't you just pin the foundation onto the ledge?
again, it's gonna be, if it's gonna create a financial burden to the applicant,
Okay.
it's still not, it's not feasible to accomplish that task.
That sounds kind of strange. Anything you build is gonna create a financial burden to the applicant, so.
But I think on the bylaw, I think that's one of the conditions, that any decision made shouldn't create a financial burden to the applicant. So it should be taken into consideration.
Would attaching it, would that be accomplished by only a covered structure or just a deck, like a walkway? I mean, I guess that would be
Question,
your,
Attach, to a breezeway, cover structure, that's the most logical. You can,
you would consider it to be
It's gotta-
acceptable, it would be covered.
it's gotta be part of the structure, yes. To.
An open deck would not be suitable.
To follow the definition of the LLA, per the bylaws, it's gotta be attached with a covered roof.
Right, so that's what we're considering. I mean, you're really considering an LLA and what we're requiring in that LLA.
But I think that
Right.
boils down to our decision is this LA acceptable without being connected, which
Right.
obviously there's some concern about.
Right.
I think that's really the question that we need to answer is it acceptable as it is or not? And then if it's not, how can it be connected? But that's not really our concern. That would be what it would need to be compliant.
Okay.
And as a
Unless we grant
reminder,
the variance.
as a reminder, we have two open hearings for this one property. The variance, which is how we just reopened it, the variance voting, and then the LAA voting. So you have to actually vote on both, for the variance, whether you approve the variance and whether you approve the special permit for the existing detached LAA.
What will be the basis for the variance?
According to what they submitted, it was soils because of the bedrock.
So the special permit would be specifically that it's not attached. We're waiving non-attachment. Would that be
That would
correct?
be.
No, that's, with all due respect, that's not,
It's the use.
the variance is that it's not attached. But as you've heard tonight, and it's still being confused, and Jose said it exactly right. That's a structural issue. And he just said, the structure isn't what's at issue. What's at issue is only the use. So, just to make this board
What
satisfied.
do you gain with the special permit if
The
it's?
special permit is to allow the use, absolutely. That we can do. We asked for the variance because this board wanted us to ask for a variance because it wasn't physically connected. And I'm saying, I don't think that was probably necessary, but we've satisfied it anyway. Because the structure has been in existence, number one. The soils are number two. We can go on. I wrote a, 5-page letter about this.
I've
I
read
think
that
all
5
that's,
page letter,
I
yeah.
think it's all laid out there. The standards for a variance have been satisfied.
To make this simple for someone like me,
Me too, maybe?
you really don't need a variance at all. What you need is the LAA.
That's my view of it, but the board asked me to put in
I
for a
remember that.
variance.
No, I remember that.
So I did. I wasn't trying to pick a fight.
I'm not fighting with you, but yeah, it's the use you want to clarify.
That's what we want the use
And
clarified.
support, yeah.
So if you vote the variance, it's just because it isn't connected, that's fine. I mean, it's kind of a fait accompli.
Well, it seems that everything's been satisfied except for one issue, that it's not attached. And that specifically has to be mentioned as either variance or the special, why we're saying it gets a special permit, or why it gets a variance, and that's the only reason we care about. He seems to have presented that it meets everything else.
It does.
I think are you saying that both of them need to be voted on? Because the special permit is for the use and the variance is just for the reason that it's not attached, correct?
According to the board, yes.
So we need to vote on both of them.
You need to vote
Yeah.
on both because the
There's
board
two-
wanted
there's
it.
two separate.
But there's no new construction involved here, so why are
Respect-
we even talking about a variance except that we
because-
requested it?
Because I didn't want to if the board denies it, the variance, my argument in court, I could tell you right away, is going to be, the variance application never needed to be filed. We did it because the board asked us to. And I'll go through the same arguments with the judge, and I think my view is the law is going to say the variance can be granted under these circumstances and that we satisfied the criteria. But if I have to argue in court, I'm going to say this whole variance application was unnecessary. I did it to accommodate questions from the board. I was trying to be polite and answer questions. And I
Well,
don't want
if-
it to come
Thank you.
back,
If-
I don't want it to come back and bite me.
If that's the case, you don't want a variance, and we would only be doing a special permit, and it would simply be based on waiving the town's bylaw that it has to be attached, rather.
But we can't waive a bylaw without a variance. We can't waive it on the special permit.
So we still need two.
Is that right?
If you grant it, then it's a non-issue.
The last time Mr. Hausler was here, if I recall correctly, I think the board asked Mr. Hausler to apply for a variance to keep the no modification between the structure and the house,
To address that.
to
was the
address that,
variance.
which he did, and to apply for a special permit for the use.
Which we did.
So
Which
the
we-
variance
we-
makes
both
way
are in
for
front
the
of us right
special
now.
use.
Right. So at this time, I think it's a matter of either approving the special permit, because the structure is grandfathering. There is, it's nothing we can do about that. Or deny the special permit, one of the two.
Do we need Paul to weigh in on this again?
I think when he weighed in is why we asked for the variance.
But I think, again,
I mean, that was his opinion when he
come
was
back and
with
ask
us.
for the
So, I
variance and
mean,
we could go off of
we-
that.
We can continue yet again.
We can't send these
Ask
people
Paul
home
for
again.
clarification.
But with respect, if the board is inclined to grant the variance, if that's what the members are gearing towards, then it becomes a non-issue. If you grant one, you're going to grant the other. The variance was the harder standard, we've satisfied it, so the special permit respectfully is a no-brainer. So if you approve both, it's a non-issue. That's all I'm saying.
May I make a motion?
Clear as mud. We're going to open this up for public comment, and
Good.
we're good, we're
For the
done.
variance.
Okay. We've taken a lot of testimony from Doug, so
Thank you.
that was probably a stretch.
Do you want to treat the special permit as separate and close this
That
one out
was
and then
gonna
move
be
on?
my-
Or do you want to blend them and take public input for the special permit
That,
component?
my motion was going to be to combine the two.
Take separate votes.
You'd rather,
We need separate votes, but in terms of public input,
gotcha.
you can opt to combine the two.
All right, so let's focus on the variance for 43 Bartlett, and we have not closed the public hearing for 43 Bartlett special permit. That make sense?
Yep.
Okay.
Did we open the special permit?
I only read in the continued public hearing is the variance. So
Okay,
we're technically not discussing
okay.
the special permit with this testimony.
Unless someone makes a phone call, there's not a lot of people here for public discussion.
So dealing with the variance now, did you want to make a motion?
Well, my motion was going to be to combine the two, but you'd say we can't.
I think the attorney's comfortable not, so they are separate applications.
So,
We're dealing with the variance
and
now.
I would make a motion to grant the variance for zoning bylaw
To
section.
close first?
You have to close
My
close the
apologies,
hearing.
okay.
What will be the basis of the variance?
Well, should we close it and then discuss it? Is that?
The board can discuss after closing, we just can't take any more input.
No more testimony.
Okay,
at this
I
point.
make a motion to
Deliberate.
close public discussion.
Steve seconds. All in favor?
It's fine. I make a motion, but I can't vote on it.
That's all right. You can do that.
But you look good
Good
at making a
question.
motion.
Now you can deliberate.
What would be the basis of the variance? When it's written up, what will we grant the variance
To allow them.
for, to allow it to
I
proceed?
guess it would be written up as soil conditions. The reason that they haven't connected or couldn't put it where it was next to the house was the soil conditions, the existence of ledge. So that would be still in effect. I mean,
But was that ever looked at? I mean, it was a garage that was converted into, right, so it was there, it was in
Right.
existence on the lot, and then he converted that third bay into an apartment.
correct.
So there were no soil conditions considered there because they just converted what was existing.
We don't know.
Well, the soil conditions were satisfied enough to install that foundation there.
Right.
Is the argument that farther down, the ledge could have been removed in some way or fashion. But we had an engineer, Katie Enright, speak to that, and she said, no, it was ledge.
Mhm.
The idea of removing the ledge
Right.
was prohibitive to the existing foundation, was, I
Well,
think, her testimony.
Yeah, part of her argument was they wanted to attach it to the house, but they couldn't.
Yeah, so
That's all there is to it.
Yeah,
because the
this
ledge was
is,
in the
you know,
way.
I mean, she's really testifying that the ledge is there.
Yeah,
She's,
there
you know,
are,
whatever is sort of
yeah, as we
hearsay
heard,
or whatever you
there
want
are
to call it.
building issues.
Yeah, one could say that they dug down 35 years ago and saw the ledge and said, oh, no, we got to move this garage 40 feet to the left. So that could have been the reason why they didn't attach it in the first place, but.
Yeah, and as said, it's been there a long time, and it's been taxed as a residence, so, you know, the town's fully aware that it's there.
I think, to go back to Glenn's question, I think it's going to say the variance is allowing it not to be attached. I think that's the
That's
whole.
what has to be there.
Right.
Right. It's a tough one.
And in your memory, have we ever granted such a variance before for non-attachment?
No, I don't believe so. I don't think this has ever been before the board. But I mean, it's fairly unique in that it's existed for an objective 35 years, the building, so it just hasn't, you know, it's a very unusual event.
Yeah.
Yeah, set a precedent.
Well, it wouldn't really set a
We're not
precedent.
held to precedence on decisions like these, because every lot is considered individually.
I know.
But I can tell you that if I was the next door neighbor and I had the same thought, you can come and you're gonna say to the board, well, you did it for him, and it's powerful.
Well, the next door neighbor, I mean, we don't know what can happen in the future, and we can't speculate. But if the next door neighbor said, well, you got your variance, you know, so I'm gonna build something so many feet away from the house, but that would be new construction. It's a whole
Correct,
different
that would be
story.
proposed.
It's really almost impossible to replicate what is going
Yeah,
on here.
right.
Because of 35 years of existence.
I think I
mean, it's-
stepped on someone's conversation here, sorry.
No, and that was kind of what I was going to go into. It's like the variance is allowing that not to be attached, and the big portion about this is that it's been there for 35 years. It's a unique situation, and that's where variances are really used for. So we're not really setting a precedent.
I agree, and to repeat myself, we're not held to any variance because every decision is individual based on the specifics of that land. So one does not necessarily apply to the other, though it certainly has been approached that way when others said, oh, you got it. So, you know, that's a common event. Does someone feel like making a motion in the affirmative if we are through discussing?
Has everybody that's here now has heard all the different presentations for 43 Bartlett? Or does it matter?
So right now, the vote is for the variance
Right.
only, and so this is the first time we're hearing testimony
Variance.
for the variance, so
It
it will
opened
be.
last month, but we took no testimony.
Correct, yeah. I remember
So the
that.
5 that are here tonight can vote on
Oh,
that.
I'm just checking, yeah.
Glenn is the alternate voting member tonight.
Yes, he is.
Steve, Brian, Charlie, Peter, and Glenn.
Mm-hmm.
Would someone like to make a motion?
I would like to make a motion to approve the variance under zoning bylaw 195-6.1 to allow the limited accessory apartment at 43 Bartlett Street to be detached from the main dwelling and any other relief deemed necessary with respect to any letters that were read into the record.
And this is just the variance.
I'll second that.
Second by Charlie. All in favor?
So
We have
that's
three.
three.
We need a supermajority.
Ryan, Stephen, and Glenn.
Ryan, Stephen, and Glenn. So we do not have,
Gotta call out the
we do
opposed.
not pass.
And the opposed would be
Opposed,
Peter and
Peter
Charlie.
and Charlie. The motion does not pass. 43 Bartlett Street, Elizabeth Gabrielle requesting an administrative appeal for the building commissioner's determination letter and a special permit under section 195, 6.1 for a pre-existing detached limited accessory apartment, LLA, and other relief deemed necessary. This property is located in the residential RB district. Now, this is the special permit, which we can take testimony on, but I think that the variance is making it moot.
Mr. Chairman, why don't we withdraw that application for the time being,
The special permit.
the special permit?
Withdraw special permit.
I think before you take any kind of votes or testimony. I have to say, I'm a little more than surprised, like shocked, at the votes for against, because I don't recall hearing any particular reasons by the two members that voted against it, of the reasons why they would vote against it, or questions about why they would vote against it. I think that's a significant problem for the town. And maybe I'm wrong, the record will speak for itself. But if we're not aware of there's a negative from either of them, I can't address what their issues are. I don't know. I'm not clairvoyant. And the members that asked questions voted affirmatively. I just suggest that there may be a need for a motion for reconsideration to avoid litigation. That's my only suggestion, sir.
I think the board stands behind its vote.
Okay.
It wasn't rushed, certainly. We debated it well.
Yep.
So I would like to get a motion to withdraw 43 Bartlett Street for the special permit, 195, 6.1.
I'll make a motion to withdraw the special permit under section 195-6.1 for pre-existing detached limited accessory apartment at 43 Bartlett Street without prejudice.
By Stephen,
Steve, second.
second by Charlie. All in favor?
Aye.
Aye.
It's unanimous.
Thank you.
And we're going to have a little discussion of the ADU LAA. Maybe Glenn has some new information. It's been a busy month for it.
Okay, so I'm meeting with David Hedison Monday morning to get some history and some numbers concerning the town's stock of senior housing, to get some basis for where things are, what kind of lead times there are. It's expected to be in the years to get into senior housing. We have, the town had voted at town meeting to go forward with the MBTA zoning. They picked two locations for that. However, when they submitted initially to the state came back with some questions or some things they felt they didn't like about it. And those things are in discussion. But one predominantly was that the area, if you decide that you want this area to be the MBTA housing, there can be no age specification. Well, the town is counting on the West Campus. There are, I think, 54 units that are supposed to be for seniors only. that area is designated as an MBTA area, and the state is saying there can be no age restrictions on the MBTA areas. So it's up in the air as to what's going to happen over there. So the stock of prescribed senior housing was supposed to be there is unclear whether it can be senior housing, because now it's part of the MBTA. It's going back to them officially, the town voted on it, but what comes back, they may still say, no, this is not acceptable because you have, in this area, you have an age discrimination of these 54 units.
So zero age discrimination for any
For
unit
the
in the
MBTA.
entire property?
For the MBTA, areas that are selected for the MBTA.
Nor is it, I'm sorry, Glenn, but
Go ahead.
nor is it low income. The law implies low income because they're saying that it needs to be close to MBTA for people that don't have transportation. But that, there's no requirement that it be low income. So there's no age restriction, there's no income restriction.
And the town, when they made their presentation in terms of the planning board, Mr. LaValle made the presentation for the planning board, it was clearly stated that these areas were picked because basically no one in his right mind is going to try to build in there because it would be cost prohibitive to do so. And even if they did, if the MBTA goes forward and says there can be no age discrimination, there is no housing for, specific housing for seniors in that area.
No funding to come?
No, nothing. It cannot be done, period. So that's a big question out there. The boards have basically picked their offices for the coming year, for the chairman. Deidre was picked again to be at the planning board.
Deidre Connolly?
I'm sorry?
Deidre Connolly?
Yes. And so I'm reaching out to her to sit down and talk about it. You have the Council of Aging, that's Fred Brosseau. So, I'm going out there, but it really starts with David, who's the one who really knows where we are. Because if we don't know where we are or how bad we are, then there's really no argument for anything. And again, I say, everyone feels we're bad. No one's saying we're in good shape as far as senior housing. But David's the one who really knows and how difficult it is to put together any senior housing. And I had pointed out, I spoke at town meeting, and I pointed out the fact that when the West Campus was approved, the thing that kind of put it over the top was when they talked about how in this whole project of roughly 450 apartments, the developer had given David Hedison the rights to develop this one piece of it where there were 54 units to be built by him, his group, that would be senior housing. And that pushed it over the top, the fact that it was going to be senior housing. So senior housing has a big card play. It's a heavy-duty card when you're playing cards. But it's still totally up in the air, and I still feel, and I'll be meeting with all these committees, that we need to have a special committee to talk about this whole thing.
It sounds like the certification by the MBTA would be up in the air, but the project itself is going to continue in the same manner.
But this age restriction, nobody knows how the state could say, you
I think
picked
what that
this
would do,
area,
if I
but you have
understand it
an
correctly,
age
would be
restriction in this area, so we
remove
don't
the
want this area.
MBTA.
They may say they don't accept that area.
Correct. That could very well happen. But that wouldn't affect the project per se.
I mean, the existing project.
Yeah, so,
Well, there's contracts signed already, to go forward. But, if this were any kind of discussion behind closed doors, the MBTA may say, if you give us this one, we'll give you that one. We'll approve your whole area, which we really don't like it for a number of reasons. But you got to get rid of this age restriction because we can't have an age restriction here and have no age restrictions anywhere else because we're setting a precedent and now other towns are going to be looking for the same thing that they don't want to have that in there at all. So it's all up in the air. But
I think the MBTA approval is up in the air, the compliance with the law, But the project's moving ahead. There's no.
No,
doubt
the
about
project is moving ahead. But they could say to the town,
it. You're not in compliance.
we
and as
don't like
such-
we don't like the area you pick for this reason, so pick a different area.
And that may be the burden the town has. It's just,
Nobody knows.
correct,
The
correct. And I
the
can
way it was
understand.
kind of left was that it's in
The
discussion.
MBTA is for all, and they're a lot federally funded. So when there's no age restriction, that's pretty critical. But if they come back to the town and say, what you picked is unacceptable because of anything, but because of the age restriction, then the town has to scramble.
And find someplace else.
But there are other opportunities, there's things happening.
Well, not according to what was presented. They picked these areas for a specific reason that they could not be redeveloped.
I understand that, we're somewhat clever about it, I think, but maybe that's, something that needs to be addressed.
Well, we've done paper overlays before with this, like with the adult entertainment 25 years ago.
Right.
You know. But
Five, I think that was 20 years ago, that was a long time
it
ago.
was shortly after. I
Somewhere
moved
up in
here.
the middle of nowhere, that area, I think, was finally
This
decided
big, I
on.
believe, yeah.
But the,
So anyway, it's got a long way to go still. But part of it is figuring out what we have.
Getting an honest assessment of what
Right.
we'll have and what we can expect over
Right.
the coming 10 years, really.
well,
And addressing issues like we had tonight, it's detached, it's not detached. Does it really have to be attached? That's for,
Well, I mean, a
Bigger group to
majority
decide.
thought it did not, but we need a supermajority to pass a variance, so that's why we have a board. I mean, that's why there's a board of seven.
and rules change, the town bylaws change over a period of time, and we have periodic reviews of them. For things that come up that people didn't think about, or changes in the world, or whatever the case may be. And that's why, we'll find out if there's support for a separate committee to study all these things.
Right.
So still got a ways to go.
What to discuss, huh?
I think that's fine, and you know what, Jose, I'll pop it in the morning.
Yeah, no problem. Take care, guys.
Good night, Jose.
Good night, Jose.
And just to kind of point out, the fact that when I brought up the point before, that it was 836 square feet,
Yes, sir.
that was added onto this house. That's basically the square footage of an ADU in the town. And that's why I brought it up. No one, I think you would be hard-pressed to find anyone against a neighbor who wanted to enlarge their house by 832 square feet. But if at the same time they said they wanted to build a ADU of 832 square feet, you might get a different argument.
Right.
And that's the only reason I brought that up.
No, it's good, it's a good comparison. I mean, I think if he had gotten the variance, or he had applied for the variance a year or two later, I don't think he would have gotten that one. It doesn't seem that the board is very, willing to give out variances. So, but having it and saying, I'm not going to further encroach,
Right.
I thought it was a reasonable request. I think if, maybe we could get David to sit down with us too at some point and attend a meeting, and we could try to get a feel for what, what he feels housing has got going.
how does this affect the ZBA, other than just future knowledge, background, that kind of thing? I'm just wondering how this information that Glenn brings from the town meeting, how it affects the Board of Appeals, other than background and
We're the licensing authority for in-law apartments. I mean, that's one of the bigger things we do.
No, I'm talking about how the MBTA quarter,
For Board of Appeals, it does not.
yeah.
It does not.
So the planning board decided where the zones are going, where they're gonna be rezoned.
Well,
think
not the planning board. Town meeting
Well,
decides.
town meeting decided, planning board
Town meeting
recommended.
decides on everything.
Yeah.
And
So
that
to give
came
that to-
today, you might want to just glance at it, it's pretty promising.
What is it?
An application for a 40B
Oh,
on Riverneck Road.
oh. The one that they,
The one that was gonna be the Amazon, if you would, distribution
Yeah.
center. They're coming in front of us.
That's not that house?
Turn the porn on, I know.
That's
He's
not
watching
that
a movie
house,
now.
Brian? I thought it was the house. It's gonna be,
No, so that's another set. This is 129 Riverneck.
Oh, that's too funny.
was it that,
Oh
is
my
it that
God.
big lot that's up on the right-hand side as you're going
The-
up?
If you go actually down Apollo Drive,
Yeah.
there's two large buildings at the very end of Apollo Drive before
Yeah.
you turn.
Oh, yeah,
And a large parking lot with a road that runs out
Yeah.
for the emergency access.
yeah, yeah.
That property was purchased. They attempted to put a warehouse there.
Old Mercury.
Yeah.
Are you
Was
talking
that
the
what
old
it was?
Mercury
Yeah.
computer?
The old
Mercury, yeah, okay.
So that was their attempt to put it, and there was a lot of, and so now they've approached it from a 40B standpoint.
Oh, that's good.
Maybe, yeah, we'll have to see what the plans show. It's pretty big.
You could build a warehouse under 40B?
I don't think so. Be 40C.
The workers are gonna sell packages. They're gonna live there.
They are doing a lot of work on the old Mercury buildings. There's workers down there all the time improving.
It was a
building side.
substantial
They're-
investment.
they're
and
doing
it is
something to it
occupied
now.
at this time. I don't know
I don't know if they're
how many
gonna,
tenants are in there or how many people are part
Yeah.
of the tenants. But
I don't know if they're gonna rent it out as light industry or what, but they're certainly not building a warehouse.
No, they're not.
Well, the town,
The
been-
plans
town
are-
in general went against
That's been-
that totally.
That would have been
Yeah, that's
crazy.
not gonna happen. So the next approach is a 40B. We'll see.
Okay.
So that'll be coming before us, and we'll debate it as the merits are.
Those are always quick and easy.
Yeah.
That's what I've heard.
Yeah. We have minutes?
Can I give a slight update on,
AI?
number 2 there? Just to give the
Yeah.
board an update, and actually this
Oh, I'd love to have you
ties
give an
into
update on
future
that.
longer zoning board of appeals meetings. So, one of the things that I just wanted to let the board know, that moving forward, and you may start noticing when I submit draft minutes, more recently, I haven't had the need to really use it for this board yet, but as we move into longer meetings, particularly knowing that there's a few 40Bs in the pipeline coming at us, we now have access to an AI software program, artificial intelligence, to help us take meeting minutes. This wasn't so much an issue with this board, but I was very far behind with the planning board's meeting minutes, since their meetings for the past year or so have averaged 3 to 4.5 hours long, and they've had up to 4 meetings a month. So my backlog was significant, and the town manager agreed to go ahead and allocate some funding to purchase the software and see. And really, we were in the beta phase. The company itself, the company has been working on the state level with the State House for many years, but in terms of municipalities, producing meeting minutes at the municipal level, it's still in the beta phase. So we've been a part of that, and we've been using it. In the last, a few weeks ago, the last planning board meeting, I was able to submit five sets of minutes using that. So it has significantly cut back on some of the time for me, because it does give me, it's producing for me a transcript that I can actually go in and click at that moment in the transcript and bring me to that moment in the video. I still have to go in and watch it. The motions are not being picked up. That's actually why I sent that
Got screwed.
email. It was, oh my God, I hope not everyone thought that. All right, so I won't sidetrack, but I'll get to the email. So one of the things is that the software doesn't pick up on everything. So I'm still going in and I'm confirming every motion that's being made. I'm confirming who's making statements if it's actually in the summary stating, because at times it's actually picking up on the wrong individuals. So I'm going through and just confirming that at least the motions and the content looks okay. Planning board meetings tend to be very lengthy and technical, and so my minutes were also very lengthy, and so it would take days sometimes to produce a set. They may not be as technical moving forward, but the summary itself so far, what we've been getting is on point. So we're using that. So as we move into our lengthier meetings in the future, you may see that some of the meeting minutes may look a little bit different, but I don't think you'll really notice a difference. I think the summaries we've been getting recently, now that they've tweaked their software programming a bit, are actually really good. And so it's a time saver for me, but I just want to let you know that that's happening because you may have heard it be brought up at planning board meetings if you're listening in, because they've mentioned it already at their meetings. So I just wanted to give everyone the heads up.
I know that those kinds of things are niche products, but they do work. My wife has a recorder that she brings to meetings and brings it home, attaches to the computer. It converts that discussion into typed pages,
transcript.
and also will recap in a more simple form what everybody had
What
to
was
say.
accomplished or
And
not.
you have to watch it, but it's very, very good and saves enormous amount of time.
Yes, it does.
As well as on the select
Future.
board, we would be 3 or 4 meetings behind. Because you can have a lot of long meetings, and it's not a easy process by the historic way of doing it.
Yeah, no more yellow pens,
I
right?
object. I need all my meetings to be handwritten.
They're not. I mean, I take small notes, but I would still, even for these meetings, I tend to go back and just review the video coverage at times to get details, such as today was a perfect example. So I had technical problems, and I was trying to get the computer to work. I didn't hear a word of what the first applicant was saying. I can't summarize that. I didn't hear a word of it. But now I can go to the video coverage, which is what I always do, and I'll just re-listen. And I know the summary because I've accepted the application, I've reviewed it. I can give a summary of what the applicant was proposing, obviously, but if there were particular questions that I want to highlight, things that need to be highlighted are being put into the actual decision document, which is particularly the case, not just with the special permits, but with variances. I really write to the T, which is why I've said before too, and Attorney Hausler touched upon that a little bit. If there are any reasons why someone is opposed to something, it's really important to, you're not mandated to, but it's important to, because I write that into the decision, and that gives our decisions
Make your
meat to it,
objections
legal,
clear
make your
and try
objections
to
clear,
formulate them
so that we have,
in a way that says I
Yeah.
cannot approve
So that
just
we have-
waiving
yeah.
this requirement.
so that we actually have legal findings for why something was voted the way it was.
Well, doesn't that go right back to the precedent of what our bylaws say, though? I mean, that's how, I know I can't discuss
Yeah,
anything
that
tonight,
is
but,
the response.
Right.
the
In general.
accurate
right,
general,
right. I mean, so if your bylaw's written a certain
so-
way and a
I
board
think
member
what-
votes a
So
certain
Yeah.
I'll be
Yeah.
writing it with the findings of what was discussed
Right.
and what the motion was
Right.
based on.
Right.
But within the decision
offers some
document, I'll forward a few,
transparency.
I should
Yeah.
forward a few of them, because not all the board members see the final decision.
Yeah.
I can forward you a few so you get an idea of what it is, what I'm doing behind the scenes when I'm typing them up and
Yeah.
drafting them up. Because we state what the facts are, we state what the findings are during the hearing.
Right.
And then in terms of the motion is detailed. If there are conditions to whatever motion you've made, those are all detailed.
Right.
So those are the important things that I still have to go in and get
Right.
detailed, even with the AI helping me.
Right.
AI is not picking up on all of that.
Right.
So it's still, I'm
Very
still
similar to
working
the
on that.
Mullen request, where
Yep.
if you missed a meeting, you can go in and see that same
Yes.
tape.
Yep.
You
Yep.
get off it what best you can.
And then, kind of as a sidetrack to that, I did send out an email to both boards today, and it was not a finger shaking at all. I didn't mean it for it to be such. It was just a reminder.
So she says.
It
If
was a
you
reminder,
don't-
and more so, and because of the lengthier meetings, more so with the planning board, there are times where just the camera Zoom, I can't tell who's raising their hand. I can't tell.
A voice.
Usually
yeah.
I can recognize the voices, but sometimes the audio is lower. That person's mic didn't pick up because someone else was talking over them. And so I'm hearing the sidebar conversation, but I can't hear some of the actual.
And that was a mention to try to,
Yeah, so that was,
as I
that,
overspeak you.
Brian, I know your mic is about as far away from you as you can get it.
so it was just to put it out there so everyone's more aware of that, just because that is a challenge sometimes in getting things on the minutes. So for what it's worth, it was not, it wasn't like bringing down the hatchet on everyone, it wasn't. But part of the reason why I mentioned the motions and making sure that it's also well heard by everyone is that both for the public and for the minutes, but also apparently I found out during this whole process of going through the meeting minutes and how we're changing them, that it actually is protocol that all chairs should be actually stating who made a motion and for those reasons.
We'll make that a habit.
Okay,
That works.
so that's why I brought it
Okay.
up, but it will be helpful for me.
I very much like it. I think Glenn has started the, yeah, we could just hold up your hand or catch my eye, and we'll let the person that's speaking finish and then go to the next one, so that we don't find ourselves too much over speaking.
Yeah, that you used to go into the,
And it's usually not an issue, I will say that.
I'm learning them, I got that whole side over there. Now I'm ganging up too, so I gotta pay attention.
I apologize if it sounded harsh, I didn't mean for it to sound harsh.
No,
I'm teasing.
didn't sound arch.
A few of the words you called me, well, they hurt, but. No, they were not, I'm
Well,
just.
can I go underneath other? We have other there.
Yeah, I always put that in there in case someone has
Well,
an
the other
update.
is like, you just mentioned a good thing, like when a motion is said, that you reiterate the motion. So therefore, in my mind, I don't think the chair should make a motion.
So the chair is allowed to make a motion, I
Who
have that
says?
right. It was in the town code of conduct book.
It wasn't a town code comment.
It absolutely was. I'll bring it in and show it to you
I
if you'd
did, I
like.
did read that.
Oh, so that's where I gleaned that information from, and because I have never made a motion as chair until I understood I could.
And
But I
that thing is
believe
right.
that it's more important to run the meeting than make the motion. And, it's not critical that I'm making the motion, so I do defer and ask for a motion.
that issue came up one time in that a board was trying to pick its officers for the next coming year, and someone nominated themselves. And they said, oh, they can't do that. And they came back and said, yes, an officer can initiate a motion.
Yes, the chair can, absolutely. I was actually under the impression you couldn't, but learning that, I said, okay, I have that ability, but I don't think I've utilized it, and I don't see the need to. If it was, something that was chaotic, I probably would do it, but otherwise, it would be just, let the motion speak from the board. I mean, we are a board of 7, going on 8, I think, and 5 voting members. 5 voting members, but we have a board of, right now, 7. So,
Must say, the motions were pretty smooth tonight. I don't know who was
yeah,
putting them all in there, but they all came off the tongue really well from what I was hearing. It was a good
Someone
motion.
nominating themselves for a position.
I'll make my first motion to approve Steve being the motion guy.
Second that.
Okay, so now, if there's not other things to speak of, we'll go to the minutes of April 4th, 2024. Want to have a chance to review them and have any
These are
corrections?
wrong? These are wrong, Becky?
Did I post the wrong ones?
No. The only thing that's wrong is the schedule. It says a motion by me to schedule a July meeting for April 11th.
Sorry, hold on. Where?
Number 2. On number 2, new business, discussed items.
Okay. Schedule a follow-up, executive, okay, so that was not, you didn't make the motion to reschedule the meeting that day?
I did, but not till April 11th.
So we did have an executive session, April 11th at 7.
I think July is.
Am I looking at it wrong? I'm oh, July, okay, yes,
That's all, that's the only correction, is July, right?
yes, so that should say.
Yeah, that's
What was
all.
that supposed to be?
It's gotta be,
The April meeting.
The
or
April meeting, because it
yeah.
was April, okay.
That was the one we went back and forth and couldn't pick a time. or a
Right.
day,
Yeah, sorry about that. Okay.
so on April 4th, you scheduled a meeting to April 11th? Is that what we're saying happened?
Yeah, so what happened was we had the April 4th meeting, and town council came, and he thought that we were having executive session that evening, but no one, he didn't reach out to me to put it on the agenda on time, so we couldn't actually have
couldn't
executive
have the
session at the
executive
end of the
session.
meeting. So the board voted to have one the following week.
April 11th.
Yep,
It's just a good
yep.
thing
So that was a
to
special meeting
advertise.
just for executive
Or-
session.
Post it.
Yep.
So me missing the April meeting got me out of 2 meetings.
Yes.
But Brian was texting you, I think, on that one, wasn't
Did I come to that?
he? Yeah.
Oh. Oh,
Yeah, I
yeah,
think
the
you
one in
said
that
that.
room over there?
Mm-hmm.
Yeah.
Yeah.
I did go to that,
Yeah, I was gonna say, you were at that one.
yeah.
Yeah.
I thought I lucked out
I think
and missed.
everybody was at that
This
one.
too.
I think I missed 2 for
you were
1.
You just wait for August, mister. You'll be missing us.
Okay, so I will, thank you, Charlie, for pointing that out. I'll make that correction.
I thought you were there. I was like, oh boy, I'm getting old.
Thinking to myself,
Well, all right,
he
well,
was sitting across the table from me.
Yeah.
Any other corrections?
Motion to approve the minutes.
I move to approve the minutes as is, with the corrections indicated.
Correction.
Ron, second by Peter. All in favor?
Yep.
Unanimous.
Confused
No,
about.
it wasn't unanimous. I didn't see all hands. go up.
Opposed to the minutes?
So, hold on, who was here that day? So,
So that would be a,
Stephen and
uh,
Glenn weren't here, so they can't vote on this one.
Right, so you just abstain.
So Brian, Charlie, Jamie's not here today, Peter, Ronnie, and Danny. So we have 5.
I get to vote. Oh,
Thank you. So,
yay.
yes.
Everybody put their hand up.
It's my first vote
Group you need.
All right.
in a year.
Hey, we're tied.
Motion to adjourn? Rod, we do not need a
All right.
second.
We do not.
All in favor?
Thank you.
Unanimous.
Thank you.
Thank you again.
Becky, thank you.
Appreciate it.